Section 27 and the Centre for Child Law are taking the South African Council for Educators, SACE, to court over the non-implementation of the ban on corporal punishment. This follows the so-called lenient sanction imposed on 2 teachers who were charged with assaulting pupils in the classroom. They are calling for harsher punishment, and I'm joined now by Dr. Faranaaz Veriava from Section 27 to unpack all of these issues. So it would seem to me many people would ask themselves, Dr. Veriava, why is this even a conversation in 2022 after all of these years since the ban on corporal punishment was introduced, after it was found that, it violated a whole host of basic human rights of children. But it seems the practice continues in pockets within the education system. And these 2 cases, just by way of context, were particularly egregious.
Yes, so let me start by saying, as you have mentioned, that corporal punishment was banned in 1996. In the case of Christian education, which was a constitutional court case, the ban on corporal punishment was upheld, and the court even went as far as saying it's not allowed, even in private schools, even where Christian schools had asked for a specific exemption. More recently, corporal punishment has even been banned in the home following a constitutional court judgment. Despite this, the General Household Survey says that at least 1 million children a year continue to experience corporal punishment. So just to characterize the case as you introduced it, what we are not asking for are harsher sentences. Rather, I would say that we are asking for appropriate sentences. So what we would like the court to do or SACE to do in each and every instance where they are faced with a corporal punishment case is to look at the nature and severity of the case and whether the best interests of the learners were taken into account. So we've had 2 cases come to Section 27, and these are our applicants in this case. And the kinds of punishments that were meted out, the corporal punishments, were both severe, but both very different. And yet there wasn't much thought applied by SACE in the kind of sanctions that they imposed in the teachers. So to just give you a sense, the first case was a teacher who hit a learner with a PVC pipe. The learner then had a brain hemorrhage, had to have an operation. She also beat another learner over the head. She then threatened these learners with telling their story to anybody else. In the other case, there was also a child that was severely beaten on the head. In each case, these teachers were given suspended sentences instead of having their name removed from the roll. Yeah. They were also just given a fine that they had to pay, a 10,000 Rand fine. So what we are saying, there needs to be more thought in what the appropriate punishments are. In some cases, it could be just attending anger management training, learning different alternatives for classroom discipline, or striking someone off the roll. But this wasn't even a consideration for SACE.
Sure. So you're saying that
we took the matter on review.
You're saying the reason for this this weakness in the system is that are the processes that are followed by SACE in dealing with these issues. I understand one of your arguments to be that there's not even room for the children themselves to be heard in some of these matters. Certainly in the case of in the 2 cases where we are representing the pupils, they were not even given the opportunity to be heard in terms of the impact on them of these assaults.
Yes, they were not, neither them nor their parents were given the opportunity to be heard. But just to say that the SACE process, in terms of the SACE Act and Code of Conduct, does provide that once there is a sanction that's imposed on an educator, the victim or the other parties involved in the matter be given the opportunity to comment on the sanction. This opportunity was not extended to the parents and the learners in these 2 instances. And in both instances, the parents were actually at the hearing, and they were put in another room, but they weren't told at all that this was the sanction. And in fact, we had one of the mothers sitting with us during the hearing today, and at one point in the hearing, she said, you know, she doesn't understand why this is happening, because she fears that the teacher who hurt her child can go on and hurt a whole lot of other children. And that's the point. How do you put a teacher back in the classroom without any rehabilitative action, without any other kind of sanction that can protect the learners going forward?
Do you have any sympathy at all for this argument that I believe was made during the hearing of the case today, that part of the consideration on the part of SACE in not calling these pupils to, you know, have an input in as far as the sanction is concerned was to avoid secondary trauma being inflicted on these pupils?
There is absolutely no merit in that. So one of the cases that we have relied on strongly is a constitutional court judgment where the justices have strongly said in matters affecting children, the voices of the children should be heard. That does not mean putting the children on the stand and allowing them to be cross-examined. This may just be speaking to their parents, if that's more appropriate, to get a sense of how the children feel. It may be, you know, just asking them to put it in writing how they feel. And that's been made very clear in the Constitutional Court judgments, that getting the voices of the children may vary, but it certainly is not about giving evidence on appropriate sanction. It is about just getting their views on appropriate sanction and letting their voices be heard in a matter that affects them so directly. And to just say that this was the first time that the rights of the learners were touted by SACE in any particular way. And in my view, the advocate was being quite opportunistic about this, because like I said, there was no sense that any learner would be cross-examined.
Beyond forcing the hand of the South African Council for Educators, Faranaaz, what are some of the systemic interventions that can be made, given the, you know, how widespread and far-flung schools are in society, and, you know, not everything happens within the easy glare of, I don't know, the institutions and bodies and organizations such as yourself, and there's a whole lot of differences of adherence to the basic fundamental human rights of pupils at some of these schools. Are you starting to have a conversation? And I know you do a lot of work in education as Section 27. In fact, that's one of your main preoccupations. Is there a conversation that's starting to say, how do we stamp out this from schools in general and make it such that, you know, it doesn't pay to violate the rights of pupils in this way?
Well, Tilasizwe, this is exactly what we are trying to do. As you know, when Section 27 takes a case, we take a case to try and look at systemic change. And like you said, a lot of these cases, the million or so cases that are happening a year, are happening mainly in areas like KwaZulu-Natal, Limpopo, and the far-reach provinces. What we are doing, we are trying to firstly, SACE has something called mandatory sanctions that they impose. What we are saying, as part of the relief that we seek in this case, we want that particular document which discusses mandatory sanctions to be revised so that the voices or that the best interests of the children are taken into account in those mandatory sentences, and that you don't just get the kind of sentences that were imposed here. So that's the one thing. The other thing that was very useful that happened today in the case is that we had the Children's Institute from the University of Cape Town intervene as a friend of the court in the case. And they brought both expert evidence and provided a lot of scholarly journal articles talking about alternatives to corporal punishment in the classroom and talking about different programs that all teachers should go through so that they can manage classroom situations, particularly where, we are dealing with overcrowded classrooms, where discipline may be difficult. In these instances, the learners were 7 and 10 years old. But there are other instances where classroom situations are complicated. And to actually empower teachers to have the tools and to have these kinds of discussions so that teachers know there are alternatives, so that parents know that there are, firstly, that there is a ban, and secondly, where that ban is not being properly enforced, there are places to go to get them to get their children's rights enforced.
Sure.
So that's what we're hoping with this case, that we will initiate systemic change.
Dr. Faranaaz Veriava from Section 27, I've got to thank you for your time. It's a case of great import. It's a really important conversation. I would argue that it's perhaps underreported. In terms of us as news media covering this particular story. Given the levels of violence in our society and the fact that, children are already being exposed to this culture of violence that we continue to lament elsewhere in society, we should be paying closer attention to this case that's playing itself out at the High Court in Pretoria. That was Dr. Faranaaz Veriava there from Section 27.